Okay, it is exactly 8:30 p.m. and today is Tuesday, June the 16th, 2020. Welcome to week 6, the final week, the final lecture of classes. By Friday, 11:59 p.m. Central Standard, the course will be over. By next Tuesday, all grades will be in. And so I'm going to take time to talk to you about the assignments for this week, one of which you already know is a quiz, which is basically your uh, final exam. So let's go down. You can see this is it, week 6. The lecture will be here after we complete it. Before we looked at the announcement, let's look at the calendar one last time. And there it is. This is where we are. Tuesday, the 16th. Initial post due tonight on the topic murder or self-defense. And then Friday, your reply post is due. Your written assignment, which is your quiz. And you know what that is. That's going to be involving chapters 4, 5, and 6, the materials, and those practice tests that we have done. Make sure you go over those things. And then your key phrase will be due. Okay. Absolutely, absolutely, absolutely no assignments will be accepted after 11:59 p.m. Central Standard Time. Be aware of that. I've said it over and over from day one, but it bears repeating several times today, and I will do that. Okay. And then that's it. So now let's go back. Close that down. Let's go to week 6 and look at the assignments quickly because there's not really much in terms of that. Your discussion posts. And so you're going to take that fact pattern here, this scenario, and your initial post. Will the clerk be able to justify self-defense in this case? Explain why or why not. And then identify a self-defense statute in your state or another state and explain why the elements have or have been met. Then your reply post, contrast yours, defend your position regarding both questions you addressed in your initial post with another post that you're replying to. Then a quiz, you know how that works. We've been talking about this since day one. It follows the same mode as your week 3, and you know how that goes. And then your live Zoom lecture. And that's it. There are no written assignments, quote, other than the discussion posts. And your quiz will be graded automatically. So this week's grades will be based on week 6 discussion posts, and then you're putting your key phrases in there that I give you at the end. So I don't have to explain to you about this quiz because we've been talking about it every week. So you should have it. All right. So let's get into the lesson content. Self-defense and defense of others, mistake of law, mistake of fact, and excuse defenses to criminal liability, and then privilege related to deadly force. So we deal with the insanity defense, the involuntary intoxication, and mistake of fact and law, and self-defense. And those are the 4 areas that we will be covering today. Then we will do for the final time the key terms for practice, and then the quiz. All right. So one of the things that I can tell you that in my many years as a lawyer, I never had a client that was able to use the insanity defense. It is a very difficult thing to accomplish, and many lawyers will tell you that the jurisdictions that operate with the insanity defense, and some don't allow it, and we'll talk about that, that it is a rare case. Um, there was an individual by the name of John Hinckley. You may or may not know that name, but he is out now. But he shot at the president at that time. And when he shot at the president, he was shooting at Reagan, but he ended up wounding a Secret Service agent who is a police officer not too far from where I live here, Terrence McCarthy. And then the I think it was Secretary of State. Anyway, he was one of the um, cabinet members, uh, James Brady, which the Brady Bill came about because he was shot by this person. And what happened is that this person was determined at that time to be insane. And so, because of that, you're going to discover when we talk about this that when a person is found not guilty by reason of insanity, that doesn't mean that they get to go home. In fact, they still are incarcerated because they end up going to a institution or hospital to be treated, and they will remain in that hospital until they recover. So it's not that easy once you get to that particular point. Um, I'll talk about an example that happened here in Illinois that I'm aware of in before I leave this section here. So anyway, in the United States, one of the affirmative defenses. Now, when we say an affirmative defense means that you did the act, but that the law excuses your actions, and so therefore it's an affirmative defense, and so it's justified or excused under the law. Self-defense is one of those, and it's commonly used. I used it many times as a defense attorney, where, matter of fact, my very first case was a double murder case where a young man um, was conducting a crap game, and these two guys came in to rob the crap game, and then he shot them. He was able to shoot them with his gun, and he shot them in the back. But I was successful with getting a jury to find him not guilty using self-defense. And everybody always wondered, how in the world you're going to get him to be found not guilty when he shot him in the back? Well, it was very easy because of the fact that I listened to what the individuals said who were at the scene. And what happened is that when he let them in the building, he locked the door, they went up the stairs, and they announced, it was only about 6 stairs. They went up those stairs and they announced that they were holding the place up. Well, he had his gun in his belt, and he got it out and he kneeled down and fired shots at both of the guys, and they hit the ground. Then he came up the stairs, stood over them, and emptied his gun in both of them. The way that I was able to prove self-defense is that the coroner's report confirmed what I already had suspected based on what the witnesses had told me, and that was that um, the shot that was fired, consistent with them facing each other with the guns, were what killed those guys. And therefore, when he stood over them to shoot them in the back, they were already dead. Therefore, the evidence was very clear that he was defending himself or others. Um, and so he did have other problems. He wasn't even supposed to have a gun. But the fact of the matter is he was found not guilty by the jury. He ended up serving a little time. Well, not really. While he was waiting on his trial to complete, it took over a year for me to get this completed and get it to trial. He ended up in custody, never made bail, and he ended up getting out right after that for being charged with having a possession of a weapon. But my point being to you is that um, that was one example of self-defense. I've had many examples of self-defense. So let's talk about the mental disorder insanity defense for right now. So when a person commits this crime, they have what they refer to as a diseased mind, or the mind is not capable of understanding the actions that individuals uh, commit. For example, uh, there is no evidence of premeditation or knowing or intent. So um, the prosecution must prove defendant had a guilty mind. But if you're able to successfully apply the insanity defense, then that person is not guilty of the act because of the fact that their mental capacity took away the ability to be of a knowing and a premeditated person. So it says so the defense has to raise this issue, um, and uh, so the proof that the person didn't have the ability to be able to commit the offense, even though they did. Okay, now having that been said, so it's a defense that, as I said already, is that when a person is found guilty by a judge or a jury of not guilty by reason of insanity, then that person is, again, as I said, committed to a mental institution and will remain there until they recover. And so the doctors will then have to determine whether that person is competent to be released into the public. All right. So it's not a very simple thing. And it's not really a victory for that individual, because that individual is going to end up in a place that they don't want to be. Their liberty will be taken away. That is why some people should understand that it is not something, especially with the fact that we are minimizing or eliminating the death penalty, that individuals do not try to use this as a basis. Um, and I'll talk about one of my last unsuccessful attempts in just a few minutes. So, but right now, let's talk about the three methods. So there are three and only three, called one, the original historical one is called the Norton. Even though it says M. Norton rule, it's really pronounced Norton. And it came out of the place where most of our laws and our jurisdiction came out of, that from England. And so it said that if at the time of committing the crime, the person had a diseased mind that prevented them from recognizing that their act was wrong. Okay. And so we call it the right wrong. So they couldn't tell the difference between right and wrong. That's pretty much how the Norton sounds. And it says here that, for example, a defendant would have to prove one, that at the time of the offense and of the homicide or the murder, that they thought that they were stabbing someone with a knife, or that in reality they thought they were using a straw. So their mind was so out of touch that they didn't recognize that the item that they had in their hand could create death to a person. And so, or, here's a or, at the time of the offense, um, they knew they were stabbing someone with a knife, but for any reason, as a result of the condition of their mind, they thought it was absolutely nothing wrong with killing the victim. So that's what I say when the basic right from wrong. As you and I know, we begin to teach right and wrong to our children when they're young. And usually, even though you don't have to be a lawyer, you pretty much know right from wrong in most situations. But in this case, you can see. Now, look at what Florida does. Florida says that at the time of the offense, that the person had an infirmity or mental disease or defect, and because of that condition, or the condition that resulted from the infirmity, didn't know what they were doing or the consequences. They couldn't appreciate the consequences. Again, it boils back down to right and wrong. So that's the Norton test. Now, the way that you remember it for purposes of exam is you're going to generally look for it as the right wrong test. That's generally the way it's called. But it's called the Norton, and it originated in England. Paying attention to the things I'm saying to you. The second method that is used only in one jurisdiction, and that's in, I believe it's New Hampshire. New Hampshire. And that is called the Durham, based on a case that came out in 1954 that basically came out and said the right wrong test is simple. And so therefore we need to make it more complicated uh, than to just say the person didn't know right from wrong. So it said that the Durham test, though, is actually saying that we don't have to go to right and wrong, and that some of the actions that the person performed by itself speaks as mental illness. The Durham test is more liberal than the Norton test and stretches the intellectual question of, and this is the only question, did that person know the difference between right and wrong that is expressed in Norton? And what it does is it stretches it way out to excuse that individual. I would probably hazard to say that one of the things that you will discover in cases where a person, if they are going to try to use this, there can't be any planning or plotting that takes place from that individual to cover up after the incident takes place. That is a dead giveaway that that person probably recognized that they did wrong at the time of the offense, and neither the Norton rule nor the Durham rule be applicable. But remember that the Durham rule is New Hampshire. Don't get confused. Norton rule does not apply in New Hampshire, and it's based upon a 54 case. All right. And then the final one is what we call the substantial capacity test. Now, what happened is this was an attempt to try to, as we say, codify it and set up a code that would take away the the Norton issue that the person didn't know the difference between right and wrong, but rather leave that as a result of the disease or defect lack substantial capacity. Substantial capacity. Now, it might sound like that's easier to prove than Norton, but it doesn't necessarily mean that. And so they'd have to have substantial capacity to appreciate to uh, to either appreciate the wrongfulness of their conduct or by the condition or the requirements of the law. For example, Wisconsin takes substantial capacity, and it says in their statute, a person is not responsible for criminal conduct at the time such conduct that as a result of a mental disease or defect the person lacked, and look for the term substantial capacity, either to appreciate the wrongfulness of their conduct or to conform to the conduct or requirements of the law. So it has to be substantial capacity, and it has to be it's a lot, and it's a very, very difficult thing. So you have to remember that all individuals are presumed to be sane, and that the burden of the defendant, as I said at the beginning, is to prove that that individual was insane at the time. And what happens is that um, psychiatrists will be hired usually by the defense attorney um, and the prosecution to determine whether that person is sane or not. And so, depending upon the state, the burden of proof to be successful with the insanity defense is either mere preponderance of the evidence or clear and convincing, not beyond a reasonable doubt. So here's the deal. It sounds like it might be easier under the mere preponderance of the evidence, but not so, not so, not so. And so finally, when look for the phrase substantial capacity to help you out in terms of whether a jurisdiction uses that or not. And if the question is you're in the state of New Hampshire, and which of the tests would you apply, then the answer has to be at this point Durham. So again, as I said, prior to trial, a separate hearing is held to determine if the person was insane. And so in these hearings, the state provides psychologists, psychiatrists who will examine the individual, and expert testimony will be provided before trial. Before trial. So the judge, and in some cases the jury, will then render a decision whether or not the defendant is insane or competent. Again, if the insane, I already told you what's going to happen, where they're going to go to a mental facility, all right, and may spend most of their lives, if not the rest of their lives. So now let me tell you of an example of a case that I'm aware of, that a young lady, she wasn't my client, her name was Amanda Wallace, and you could actually research it or Google it, Amanda, Amanda Wallace. And Amanda Wallace was a woman in Illinois who had a child, and you know, um, give me a second. Okay. And so anyway, Amanda Wallace, I'm going to tell you a little bit about her. Amanda Wallace was, I'm going to tell you, Here we go. Amanda Wallace. Here we go. So Amanda Wallace, if you look at the pictures of Amanda Wallace, you'll see that this person was sentenced to life in prison in 1996. And what happened is that she took a child that was given back to her by the Department of Children Family Services, and she she died actually about a year or so later after that because um, she strangled herself while she was in prison. Um, but remember what she did though is that she actually took her own child, and about 3 days it says after um, she was in custody, she strangled herself. But she took a 2-year-old boy and she uh, took that child and hung that child, and that child was killed. Well, I saw her in prison, not in prison, in jail while they were waiting trial. And she was in a corner and she was rocking and rocking, and you could see that something was seriously wrong with her. And so we say generally that you almost have to really believe that your actions didn't fit what you were doing. And it was her actions under our jurisdiction that she thought that she was hanging an animal, but not a human being. And so as a result, she was found not guilty by reason of insanity under the substantial capacity test in Illinois that we have here. So it's not that easy. So we call it the Amanda Wallace rule. That's what we call it. So I invite you to take a look at that. When I had a young man who committed a heinous murder, and I tried to get him to accept a plea of guilty, but he wouldn't. But this young man had a young lady who was a meter maid came to his house to turn on the gas, and it was just he and her in the house. He was 17 at the time and never had been in any trouble. And when she bent over to light the pilot and the stove, he just lost it. Well, he grabbed her, he raped her, and then tied her up. Well, he thought that she was going to tell, so he took a knife and he kept stabbing her and stabbing her. And every time it said in the statement that she said she wasn't going to tell, she wasn't going to tell. This was in his statement that I had as evidence that was presented, until finally she died. She laid limp. Well, he took her body, and then now the offense that I said sounds like a pretty um, sick person. Yes, that's a sick person. But I did my due diligence. I filed a motion, had the doctor to examine him. His mom couldn't afford um, her own doctor, but there was a Dr. Reifman who was a psychiatrist that examined individuals in Cook County, and he examined him and came back with that he was not guilt, that he was sane at the time of the offense. Now, one of the things that he did after he did this, he took the body, put her in a garbage can, and rolled the garbage can a few blocks away from where he lived. And when he rolled the garbage can away, um, later on they found it because the garbage cans in the city are labeled with a serial number, tied it back to his address. But anyway, he took her underwear and hid it up under his mattress and knife. So what he did was try to cover up. And so as a result of that, I'm saying that he didn't fit the mold. I knew it wasn't, but I still had to do the job of filing the motion, and he was found which that he was fit for trial and that he was not insane at the time of the offense. So that's one of the things that people should understand, that it's very, very difficult. And then I did tell you this, or I didn't tell you this, I should let you know that there are some jurisdictions that don't even apply the death penalty. I mean, not the death penalty, but the insanity defense. I don't think I have a list of them here, but there are some jurisdictions within the United States. Oh, here it is. The insanity defense is allowed within most states except Idaho, Kansas, Montana, and Utah. Okay, those 4 states don't allow for guilty but mentally ill verdicts. In those states, if a person is determined to be not guilty by mental disorder, the defendant then too is committed into a hospital. But they don't apply the same standard. So, all right. Any questions about the insanity defense? Okay. Moving right along. Involuntary intoxication. So what is involuntary intoxication? Well, intoxication is an affirmative defense if it was done involuntarily. In other words, taking a drink and getting intoxicated and then saying you were intoxicated is not going to fly, okay? Unless you didn't know. Now, I'll give you some examples of what I'm talking about in a few minutes. In some jurisdictions, they talk about, like in the state of Michigan, under the influence of impairment by alcohol or drugs is prohibited. Exception, it is an affirmative defense to a specific intent crime. That is a crime that which the defendant has the burden of proof by the preponderance of the evidence that they did, that he or she voluntarily consumed, legally obtained, and properly used medication and didn't know or should not have known that they were being intoxicated. So that usually applies in a situation where a person can over medicate themselves and by preponderance of the evidence. In Kansas, a person charged with a crime was in an intoxicated condition at the time of the alleged crime was committed as a defense only if the condition was involuntarily produced and rendered that person substantially incapable of knowing or understanding the wrongfulness of such conduct and conforming to the requirements of the law. What does all that mean? You know what a Mickey is? You know what a Mickey is? A Mickey is something that usually you'll hear somebody say that somebody slipped something in their drink, something that will send them on a trip or knock them out. And it could be alcohol or non-alcohol, but that's what a Mickey is. Yeah, something like that. But the term Mickey is a term that you'll hear a lot of times in criminal court. And so what happens is that it has to be in a situation where that person didn't contribute to it and didn't know the situation. And so they were put in a situation where whatever it was they took denied them the ability to be able to know what we learned from the insanity defense of right and wrong. But it must be involuntarily. So let me show you this last one. This is kind of like the Mickey I was talking about. Involuntary intoxication may happen if a person has their drink spiked. That's another way of putting a Mickey in. With an intoxicating substance, or they may have unforeseen adverse reaction to some lawfully prescribed medication. And here's an example, a scenario. where Jim, a college student, has been up partying all night, but he has to take a test the next day and doesn't want to fall asleep in class. So a classmate offers him a white pill and says, "Oh, it's a caffeine pill." That's what he told them, and that it'll help you stay alert. However, he was lying, and the pill was actually a methamphetamine hydrochloride pill. You know about that, right? From J250. And Jim uh, has an adverse effect for him, causing him to go into a panic and a rage. And while in this stage, he breaks the windows of a store, destroys merchandise, and he's arrested. So Jim could prove in the defense that he was involuntarily intoxicated, and he could be found not guilty of vandalism because the intoxication actually put him in the state where he couldn't tell right from wrong in terms of what he was doing. Does that make sense? Okay. And that's pretty much it for involuntary intoxication. So we got mistake of fact and self-defense. That's the one we're going to finish. But actually, we've already talked about that, so we'll not spend a lot on that. So here's mistake of fact. It means what it says. When somebody commits a crime but misunderstood some fact that negated the element of the crime. So now remember the old adage, ignorance of the law is not an excuse. Now, here's an example of what I'm talking about. In Missouri, a person is not relieved of criminal liability because they engage in such conduct under mistaken belief uh, of fact or law, unless the mistake negates the existence of the mental state required by the offense. So, in other words, the mistake of fact statute in Missouri says the defense can be claimed if the mistaken action is related to an element of the law in question. Here's an example to make it clear for you, and then we'll move on. Lisa is making a large purchase of home goods at a store, including a push mower. That's a large box, which she puts at the bottom of the cart. You know how you go to the store and you put water at the bottom or something like that? That's at the bottom. And the top of her cart was filled with items, and she pays for them, and she's distracted by her phone and doesn't necessarily pay attention to the clerk to ensure that all items are scanned. Well, she pays, for the bill and leaves the store. She's then stopped by the loss prevention officer, who informs her she didn't pay for the lawnmower. The loss prevention officer, instead of giving her an opportunity to pay it, he calls the police and requests that she be charged with theft. So that's ridiculous. Okay. Lisa would likely be able to say it was a mistake of fact because she didn't have the intent to steal it, but she intended to pay for the merchandise. So that's what we mean by a mistake of fact. I remember I went to Walmart and we had these little juice drinks, and they had rung up the juice drinks, and I was in one of those little riding things around that seniors ride around in. So I ride around it because the floor is so hard, and this place is on my knees. So I had forgotten my wallet. So my wife stayed in there while they rang it up. And so I went to the car. And when I got to the car to reach for my wallet, I noticed that it was one of those drinks that was in the basket that was never rung up. So if I had been stopped by the loss prevention officer, then I could argue the same thing. However, I was not. But what I did was I said, I'm taking this back in. And I did. And I took it back in. And then the young lady, she says, "Oh, thank you, sir, for being so honest." She said, "But I'm going to pay for this for you." And she did. But my point being is that that's how you get mistake of fact. Now, I represented a young lady one time while she was in college, and she was with a bunch of girls and they went shopping at a store, and they were arrested for theft. And the act that they committed was that they were taking tags. Now it's fixed a little bit more now because you have the scan and all that stuff. But they switched the tags and paid for it with the lesser amount. And they were on camera doing it. And my client was with them, but I was able to defend her successfully because I was able to prove while she was with them, she didn't participate in what they did. But at any rate, those girls were all found guilty of theft because they weren't paying the price. So they were obviously committing a crime there in terms of it. So you see what I'm talking about, mistake of fact. All right, you're going to run across some of these, by the way, in that test, by the way. So let's talk about mistake of law. What is mistake of law? Now, mistake of law is something that, as I said earlier at the top, that ignorance of the law is no excuse, but that the person can claim that they didn't know, um, but they believe that their actions were legal. They believed it. Now, mistake of law is not the same as ignorance of the law, as I said, um, that exist. Mistake of law can be applied in some of these cases, and I'm getting ready to show you some now that make sense. For example, and pay close attention because these come up. A person relied upon a law that was later found to be unconstitutional. Then that person would probably be able to use a mistake of law because the law was unconstitutional. So therefore, it would go back to their committing the offense, and that their acts, if it was unconstitutional, then it was unconstitutional before that. So it has to be declared to be unconstitutional. A person acts in good faith, consistent with a judicial opinion, but misapplied it. In other words, tried to apply a statute or judicial court opinion, but didn't apply it correctly. That could be an argument for a mistake of law. A person acted upon advice that was given by a person or agency responsible with administering the law, for example, a police officer, and it's determined that they run into a problem. And you're going to see that in just a few minutes. Show you one of those. And then you'll see some of those in our practice. A person commits an act contrary to law that has yet to be published. In other words, it's illegal, but nobody knows. So it's not going to be held successfully against that person. All right. Now let's show you how those things I just talked about generally apply across the board by the state of North Dakota, in a statute that says mistake of law, which states that a person's good faith belief that their conduct doesn't constitute a crime and raises it as an affirmative defense if they acted in reliance on a statement of law contained in a statute. So they relied upon what the statute said, a judicial opinion, order, or judgment. We talked about that. Administrative order or grant of permission. And then finally, the public servant or body person charged with enforcing the law misinterprets administration or gives them the wrong information. Those kinds of things. So like I said again, it says you should note that within the definition example of the mistake of law defense, there is no reference to the idea of ignorance, but rather permits the defense if it's by mistake. So let me show you an example of North Dakota, and this is what I was talking about earlier. Paul had a suspended driver's license. He wanted to drive an ATV to work. His mother reached out to the local sheriff's department and asked the sheriff's deputy if Paul could operate his ATV, even though his license was suspended. Okay? Paul was advised that he could operate his ATV as long as he followed the other laws, like not speeding or so forth and so on. So one day he was on his way to work and he was stopped for speeding for his ATV. Now, when he was stopped and he was speeding, that's one thing. But then he was cited for operating with a suspended license. And he was convicted of operating while suspended a license. And the trial court didn't permit the jury to consider mistake of law because he could say, hey, I relied upon the sheriff's office and that's why I did it. So when Renner's decision, he appealed. So he was found guilty and appealed, and it was overturned. The appeals court judges said that the trial court made a mistake or erred, and the mistake of law should have been permitted in this case. Because the only reason Paul drove his ATV while having his license suspended, not because he was hiding like some people do, but because he was given okay by a sheriff's deputy charged with enforcing the law. Is that pretty clear? Okay. So now let's conclude what we're going to talk about with dealing with self-defense. And there's some things that I'm not going to go into details with, but I want to just basically say what I said earlier, is that a person, self-defense, presume that, and the defendant raises as an affirmative defense to stop an unlawful interference against them or someone else. Now, the interference can include being punched, shoved, kicked, grabbed, strangled, or held against one's will. However, the amount of force used must be appropriate to stop the unlawful interference. But if it goes beyond that, then it's not going to be self-defense. So, in other words, the unusual interference is stopped. The force must stop and cannot escalate beyond that. Okay? Now, so if somebody pulls a gun on you, you can pull a gun on them and shoot them. That's different. But here's some examples of what I'm talking about. The victim, Bob, is walking on a sidewalk with his girlfriend, and they're approached by a drunk man who threatens to punch Bob in the face. So Bob attempts to avoid the conflict and say to the guy, just keep on going. The man shoves Bob, draws his fist back to hit him. Bob reacts quicker, punches the man in the face, and he falls on the ground. So far, so good. But Bob was upset because he had just tried to assault him. So he jumps upon the man, beat him until he becomes unconscious. Margaret pulls Bob off of the man, and they wait for the police to arrive. So the question here, and I'm going to answer them in the interest of time, was the initial force used by Bob to stop the intoxicated man from hitting the ground justified? Probably yes. But when he got on top of the man, did he go too far? Yes. So that's the point. That's the point. So it must be sufficient to deal with the circumstances. Here's what we say in our jurisdiction here. And this is what I'm very, very, very familiar with. It says a person is justified in the use of force against another when and to the extent that they reasonably believe that the conduct is necessary to defend himself or another against imminent use of unlawful force. However, it says he is justified in the use of force which is intended to or likely to cause death or great bodily harm only if the reasonable belief that such force is necessary to prevent imminent death or great bodily harm to himself or another for the commission of a forcible felony. That fit exactly what I just said earlier about my case, because these guys pulled guns, or even if they had knives and he shot them, same thing. The point of the matter is that it fit in that mode. Okay, you see how under our jurisdiction, Illinois, that's how I won my case, is because the force was reasonable. Now, um, a lot of times we have a situation where we're talking about excessive force. We're not going to talk about that so much today. We talked about that a few weeks ago. But the point of the matter is that if, for example, like let's use the chokehold, for example, the situation of what happened with George Floyd. That was totally um, a use of excessive force, because he didn't have to do what he did. The man was in handcuffs, face down, and so forth and so on. My point being to you is this, is that the amount of force that's used in a situation must be tantamount to the amount of force that you are facing or engaged with. Okay, so you can't go beyond that. All right. So talking about what happened with Bob, it's apparent that Bob's unlawful use of force was justified. However, Bob committed great bodily harm when he beat the man into unconsciousness, and it's important to remember that. Now, you hear people talking about stand your ground, but many states in the U.S. don't require a person to retreat or retreat anymore using self-defense. They used to. I hated that, but they allow people to stand their ground. And what that means is that it doesn't require a person to retreat, presuming they were not engaged in unlawful activity and have the right to be where they were where the incident happened. Before using force to stop unlawful interference, therefore individuals cannot assert a stand your ground claim if they were committing a crime when they are attacked. Also, people cannot claim self-defense in cases where they provoked the attack. Okay, so one of the problems that people had with the Trayvon Martin case was that George Zimmerman was told to not approach the young man and to stay where he was. Oh yeah. Well, you know what? Those kind of cases are cases that would probably fall under, well, she stand her ground could be argued in a situation like that, um, because you know you're down in Florida. But the point of the matter is that there are other ways too that can be defended. But yeah, that's a way to do that as well. Definitely, definitely. Okay, because we get ready to get and talk about exactly what you just said right now in the next section. The battered women syndrome. You learned about domestic violence. We talked about that early, that it takes place as a common offense. And sometimes the victims reach a stage where they have been subjected to this for many, many, many years, months, days, hours. And what is developed is what we call BWS, or battered women's syndrome. And it's been used across the country to justify the shooting or murder of an abuser by their victim. That's what I just said to you a few minutes ago, Brother Presley. I was talking about that, and I had this in mind. And it's a mental condition or emotional disorder that sets up because that person's been so beaten down that they expect to be beaten, and so they take steps to protect themselves. And it's been used in many cases, um, and it's must be raised as a defense. For example, in this case here, Diane has been physically abused multiple times by her husband for the past 10 years. Each time it occurs, Jim is drunk, and that's when she's battered. And the worst has she's been knocked and choked and unconscious before. So one night, Jim comes home drunk, and they begin to argue over Jim's drinking problem. Jim begins to escalate, and Diane, fearful that she will be battered again, shoots him. And she's likely to argue self-defense in conjunction with BWS. That's what I was talking about a few minutes ago. In that instance, you were talking about stand your ground. Uh, nah, not me. I mean, if she's been the victim of abuse and beatings constantly, a good lawyer and would be able to take a jury and get her found not guilty by reason of raising the BWS syndrome. Okay. And then there's a video down that you can take a look at it if you desire that. Now, I had a young lady that I knew real well. She shot and killed her husband. She had been beaten by him many, many, many times. But she had a problem, which I think I probably could have overcome. But here's what she did. When he came, after he did what he did, she waited for him to go to sleep. When he went to sleep, she got a gun and she shot him while he was asleep. Well, she was found guilty of murder or involuntary manslaughter, and she ended up going to jail. But a good lawyer would have been able to argue this battered women syndrome. But the problem that she had with the syndrome situation that had happened in the situation is that there was some time had lapsed between the beating and the time that he did this. She had time to get away. But then what she decided to do was she said, I'm going to get him. So that meant that she premeditated and planned it and got the gun and shot and killed him, and he died. So it was troublesome for her to use the battered women syndrome. So the battered women syndrome has to operate almost the same way as involuntary manslaughter, or manslaughter, should I say, that we talked about some weeks ago, in the heat of passion or in a situation where you are actually fearful at that time that you commit the offense that you are in danger, not letting a cooling off period go by where you have a chance to plan. Everybody got that? Now, I'm not saying that it's impossible. I'm saying that the normal course of it, because juries can find whatever they want to find with it. So, all right. So the castle doctrine is very simply that a person is able to protect their home, the place that they live, and it doesn't require. Now listen to this one. Interestingly, it doesn't require the person within the dwelling to retreat, but must prove that the person entering it did so with the intent of causing great bodily harm or death to somebody else within the dwelling. This is normally required to use deadly force. Instead, people within the dwelling, when unlawful entry is made, can use deadly force to stop the intrusion. Does this sound like a scenario that you all are familiar with? Which one? Happened in Kentucky. Breonna Taylor. This fit perfectly this. Now, these were police, but did they know that? Did her boyfriend, who, as he already found out, now he wasn't ever charged, used his weapon? That's under the castle doctrine. You can protect your home in those conditions. Unfortunately, um, police uh, didn't do the right thing, and they started firing because these people were firing because of the fact that they thought that this was happening, that it was an intruder. And that's exactly what the castle doctrine does. And so I'm not going to go over the specifics, but it's interesting. Notice this, that within this statute, this is Kentucky, the same state that I got through talking about. A person is presumed to have a reasonable fear or imminent peril of death or great bodily harm to himself or another when using defensive force that is intended or likely to cause great bodily harm if the person against whom the defensive force was used is in the process of unlawfully and forcibly entering. Now, that's the key. They say, well, it was law enforcement officers. But my point being is just so you understand the castle doctrine. That's why he never should have been charged, her boyfriend, because he had legally had a carry conceal and he was using it. And he was initially, and then they dropped the charges because under this statute, they didn't know what was going on. And it's unfortunate what happened, that it resulted in Breonna Taylor's death. But if you were in a situation like that and you heard that and you had a weapon, you were within your rights to shoot whoever it is. You don't have to have nobody ask who is it. No, you just hear the sound and all of a sudden and you go in that direction. You can shoot that individual. Okay. The individual who used defensive force knew or had reason to believe that the unlawful or forceful entry was occurring or had occurred. That's what they thought. But note that when the Kentucky statute says that the reasonable fear of imminent peril, death, or great bodily harm to a person within a protected area, it is presumed because you're in your house. Well, they were in their beds. Therefore, deadly force is justified to stop the intrusion. Okay. And it is also important to note that the castle doctrine statutes also have exceptions uh, that prevent the misuse of deadly force. And then it talks about the Kentucky castle doctrine. So that's what protected Breonna Taylor's boyfriend. Finally, it says it's important to note that this deadly force privilege only applies when the dwelling is occupied. So if a homeowner is at work and sees a burglary inside his home via a closed circuit system, you know, like people have, you can't drive home and then shooting. No, you can't do that. You should be getting the police. But that's because in the castle doctrine, you're considered to be vulnerable in your own home. The final thing we're not going to spend a lot of time on because we have talked so much about it in the last few weeks, the use of force by police officers. Um, and it's so I'm not even going to go over this section because we've already had so much time to deal with this. And right now, many jurisdictions, as I'm speaking, are in the process of dealing with changing the use of force by police officers based upon the George Floyd and other um, situations, Philando Castile, and many other cases that have down through the years. The Breonna Taylor, same thing, right? So that's it for that. All right, so now any questions about any of these things? Or do you need any questions? Do you need any comments about the use of force by police officers at this time? Do you? Now, I think that we've had quite a bit. We talked about this some weeks ago when I did my opening 2 weeks ago, week 4, I believe it was. Okay. Wait a minute, let me see that again. You said, yeah, 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 you're right. We are unfortunately clear on that. Um, but yep, yep. Clear enough that we know that those of you who are my students understand my position in terms of dealing with that type of thing. So let's do some of these practice things because you have a midterm, as I call it, they call it a quiz coming up. So now let's take a little time to go over this. Okay, applied to the intoxication defense. The level of proof necessary to prove an intoxication defense. A preponderance is often expressed as 51% certainty, merely more than half certain. Preponderance of the evidence. Okay, like in a civil case, it's preponderance of the evidence. So what it's trying to tell you is that this is a definition of preponderance of the evidence. And it says it in here. It actually gives you a clue. People, in your questions, you're going to find the answers most of the time. Used as a defense, a person can only successfully claim intoxication as a defense to criminal liability if the intoxicated or impaired state was involuntarily caused. So what do we call that? It's already in there. Intoxication. Okay. Or involuntary intoxication. A defense that can be claimed if the person violated a law, but they believed his or her actions were legal. What is that? That's right. Last one I'm going to do here. Type of affirmative defense, including use of force, self-defense, defense of others, and deadly force that justify the otherwise unlawful actions. What's that called? It's actually in the answer. Justification defense. But if justification and defense and self-defense will not be in the same question, but it is exactly that. It's justified. But it's in here. It says self-defense, defense of others, that justifies it. So it's a justify. Well, all of these are what they call justification defenses. That's what they're saying. All right, so go through and look at the rest of them. So now let's go to the next section. This is a practice, mistake of law or mistake of fact. This is where you're going to see some of those things that I talked about earlier. Jane has a white cat named Snowball that has a pink collar and is let outside each day. One day the cat don't return. Days later, while looking for her cat, she finds Snowball and brings her home. Later, she discovers the same day that the pink collar has a tag that says Princess on it. Jane contacts the police, but she fears that she will be arrested for theft. What is that? Exactly. Because she reasonably believed found out that it was not her cat. She didn't intend to steal it. Let's say, for example, if she decided to keep the cat anyway after that, then would it be theft? Yep, yep, yep. Eric waves down a police officer and he asks, my landlord locked me out of my apartment. Can I break in to get my stuff? The police officer responds, go ahead, it's your place. Eric breaks in and the landlord demands that he be arrested for burglary. This is what defense could he raise? Yeah, but that's a stupid police officer. That's a dumb police officer. Everybody, common sense. No, you can't just do that. Okay, it's not just your place. You got to go to court. So you'd have to go to court there. So yeah, so mistaken. Yeah, because the police is an official carrying out. Okay, remember those things I talked about earlier. Officer White is working a theft case and believes he has the right to enter without a warrant the suspect's apartment to retrieve stolen items just to be sure. Officer White speaks with the on-call judge and explains the case to him. The judge advises Officer White to enter the apartment and retrieve the items, which he does. It's later determined that he violated the defendant's Fourth Amendment rights, which I would probably say would end up being the case. So what is it? What is it? Mistake of what? Yep, mistake of law because the judge is a recognized authority. So you see how those work, okay? So you might see a few of those in there. I'm not going to comment any further beyond that because I've seen the test. And then the final thing, these questions, I guarantee will be there. And those of you who you know already, you heard what I said before you took the test in week 3, and there was some in there. And some people said to me, hey, thanks for going over that, or at least bringing this to my attention, because one was exactly from there. I said, yeah, it wasn't exactly, but it was close to it, but close enough to have the same answer. Okay, now remember I talked to you about these things. You are defending a case where the defendant is accused of killing his girlfriend during a schizophrenic attack and believed he had to kill his girlfriend because she was the devil. You don't believe that Derek knew the difference between right and wrong at that moment. The blank rule would be most applicable in this case. Which one? Yep, because he didn't know right from wrong. The intoxication defense, that don't even apply. The substantial capacity doesn't apply either because you don't see the words substantially in there. And then Durham, remember I told you about that. You will less likely see that. David is hanging out with friends at a local bar. Somebody places an unknown liquid in his drink, which caused him to go crazy, strip off his clothes, throw objects through the window. He's arrested, transported to local hospital. Next day, he has no recollection of the event. What affirmative defense will David claim? Yeah, not insanity, even though that's some insane actions, but what caused him that? Mistake of law? No. Coercion? No. You're right. It's the intoxication. Yep, because it was involuntarily caused. That's the key. What level of proof must be met in order to successfully prove an intoxication defense? Probable cause, mere preponderance of evidence, beyond a reasonable doubt, or reasonable suspicion. I'm laughing because two of them They don't even, actually, three of them don't fit in there at all. What? Which one? You all are quiet on this one. Okay. All right. Let me take them one by one. Is reasonable suspicion, does it have anything to do with this? Does reasonable suspicion have anything to do with this? No. Beyond a reasonable doubt. Is that correct? Isn't that the standard of proof in a criminal case? No. That's 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 in a criminal case. But we're proving a defense. Is it probable cause? No, that's the standard for an arrest or a warrant. It's enough. It's just mere preponderance of the evidence. 51%. Remember that? Remember that, Kara? 51% certainty? Uh-huh. See, that's it. So you got tricked. All right. Last one we're going to do. Jackson is at a garage sale looking to buy stools. Unbeknownst to Jackson, another shopper puts a ratchet on a table with other items. A sign on the table reads, "Free, take one." Jackson takes the ratchet set and walks away. The rummage sale owners call police and demand that Jackson be arrested for theft. What defense is Jackson likely to claim? Yeah, yeah, because how would he know? It's not ignorance. Remember, we already talked about that. It's not adequate provocation. It's not adequate mistake of law. But yeah, I mean, the sign said free stuff, and you took it. Okay, so mistake of fact is when someone commits a crime but misunderstood. One last one. That's halfway through it. Matthew wishes to grow his own marijuana for medical use only. Presley is in the class you used to be in, Kara. That's why he jumped out there quick. Okay, okay. You should remember this too, because you had the class before he did. But yeah, that's why he jumped right out there, bam, with the answer. Okay, and that's it, guys. For that, um, I want to give you um, a phrase, and I want you to tell me what you think might fit. Anybody? Because I already have one. Nope. Any other guesses? Nope. Neither of those two. It's a widely used defense. There we go. Okay. All right. Self-defense. That's it. There it is. That is it. That is it. Self-defense. Well, guys, I just want to take the time to thank you all for um, thank you. I'm glad you enjoyed the course. You guys should know that I enjoy teaching this class. I love criminal law is my forte. All of them I enjoy. The drugs and crime I enjoy too for other reasons. Uh, you know, thank you. And I encourage each of my students to take away some of the things that I share with you because, again, ethical, professional, and educated. That's what I want you all to do. Make me proud. Make me say, I stick my chest out and says, yep, I had them as my students. Yeah, and they're not being arrested or charged with committing an offense. And then if you're law enforcement, that you're learning how to conduct yourself. If you're corrections, if you're probation, parole, if you're a substance abuse counselor, if you're doing any of these types of things, that you are helping people find yourself in a situation. I know some substance abuse counselors that um, they need substance abuse help because, you know, but you need to make sure that you do that. Make sure, make sure. And so I hope to see you guys in some of my other classes after this. There's several other classes I teach. Contemporary Issues in Criminal Justice is an 11-week class now that they're talking about changing it to a 5.5. I will be glad because it's one of my last ones that I teach, that 11 weeks. Um, I like 5.5 classes because you hit them and bam, and you're moving on. So, you know, yep, yeah, I will be in teaching in the bachelor's program. Right now I teach constitutional law, and if you take that, you'll have me. I love that class. And then if you take the class of realities in criminal justice, though I hope they fix that one. That one we talk a whole lot about the OJ case and so forth and so on, and we talk about some other things. I want them to contemporize that a little bit more. So anyway, I'm going to say good night to you guys. You know, and I tell you the truth. Enjoy your break. I will be submitting your grades, as I said, by Monday and by Tuesday night. Uh, well, they're really due. They're due Monday night, I should say. So you by Tuesday morning they'll be in because grades are due in by 11:59 p.m. Central Standard Time. I got one of those on me too as well. Okay, so I'm gonna say good night. You guys stay safe, and you know, just keep up the great work that you guys are all capable of. All right, so good night.